Okay. All right, people. We're going to do... Hold on. Let me get this angle here. We're going to do a quick vlog. No editing because I'm making a barbecue for dinner. An act which in Quebec City would be illegal right now. All right, so earlier this week, we had the biggest breaking news of the Coutts 4. Those are the 4 men who were arrested on conspiracy to commit murder charges over 2 years ago, have been in remand, pretrial detention, without a trial, denied bail for over 2 years. And earlier this week, 2 of the 4 men, Lysak and Morin, struck a deal and were granted their God-given right to freedom, even if they were properly charged for the alleged crimes. They should have gotten bail given the other precedent in Canada for who gets bail, notwithstanding the accusations against them. Okay, set that aside. 2 of the 4 men have struck a deal and have been released from pretrial detention, from remand. And I went on something of a rant earlier this week, the day that it happened, raging against the machine that is the Trudeau regime of Canada and the weaponized, politicized, so-called justice system in Canada that has been holding these 4 men as political prisoners for the last 2 years plus. At the time of my rant, what was known was that the 2 men pleaded guilty to much lesser firearm-related charges. One of the 2 pleaded guilty to a charge that was actually not even in the original indictment. And I said, where were these offers of a plea deal 2 years ago? You let 2 of the 4 men off who are accused of conspiracy to commit murder, who the day before yesterday were so dangerous they had to be denied bail. All of a sudden, they plead guilty to 2 lesser gun charges and they're given their freedom, which highlighted the weaponization, the injustice of their detainment for over 2 years, in my humble opinion. And I said that this represented a full capitulation by the Crown, who saw their entire case unraveling before their eyes, that they got as much political profit out of these 4 political prisoners as they could because Commissioner Rouleau used them as the excuse to justify and ratify Justin Trudeau's invocation of the Emergencies Act. And now that the federal court recently came down and declared Justin Trudeau's invocation of the Emergencies Act to be unlawful and illegal and unconstitutional, well, now these 4 men in pretrial detention are no longer assets, they are liabilities, because the trial would expose the corruption of the prosecution of these men. That is the pith and substance of my earlier rant of this week, and I stand by it, but there has been additional information that should be brought to the world's attention so that you can all reassess accordingly, as I will. I have reassessed in light of this information, but I'm not sure that it changes anything of my opinion. The day after the 2 men were released, Lysak and Morin, their agreed stipulation of facts, that is to say, the statements of facts to which they agree as part of their plea deals, was released, and Lysak's stipulation of fact, innocuous, supported the basis of my righteous and rightful rant of the day before. Morin's stipulation of fact, however, includes one paragraph which I am still trying to determine how to digest it. There are some who rightly and understandably believe that it looks like it might be throwing the 2 remaining defendants who are still in pretrial detention and remand, that it might be throwing them under the bus. And I'm giving this assessment without any judgment to Morin. None of us have been locked up in remand for over 2 years. None of us can judge unless we've walked a mile or 2 years in those shoes. This is merely a factual assessment of the facts as they currently stand and whether or not it would attenuate or otherwise modify my initial rant. And my assessment is no, it doesn't. Everything I said was equally true as it was when I said it. That being said, I'm sufficiently self-reflective to ask myself, is that a question of me defending the position I've already taken? Is that a question of me being too optimistic and seeing it through the blinders of what I want to happen? Doesn't matter. We're going to go through their stipulations of fact, and I'm going to tell you what the new fact is, and we're going to see how we digest that together. Sticking only to the relevant passages, this is His Majesty the King and Christopher Lysak agreed statement of facts. Pursuant to the provisions of Section 655 of the Criminal Code of Canada, the following numbered paragraphs contain facts which are alleged by the Crown and admitted by the accused, Christopher Lysak, for the purposes of dispensing with formal proof thereof before this court on the charge that he, on or about February 13, 2022, at or near Coutts, Alberta, being the holder of an authorization or a license under which he may possess a restricted firearm, to wit, a Sig Sauer, and you got the number there, possessed the restricted firearm at a place other than a place indicated on the authorization or license as being a place where he may possess possess it, contrary to Section 93(1) of the Criminal Code of Canada. And full credit to Mocha Bezigran, who pulled this up, as you can see from the watermark on the document. Then we've got some statements of fact. You can read them on your own if you so choose. Paragraph 4, during the convoy protest, Mr. Lysak stayed in one of the trailers at 306 First Avenue North, Coutts, Alberta. On or about February 10 or 11, 2022, Mr. Lysak emptied out his ammunition bag to use the bag for laundry and discovered that his Sig Sauer semi-automatic handgun was inside the bag. Mr. Lysak had forgotten he had quickly placed the handgun in the bag when his daughters knocked on his bedroom door at home in Lethbridge before he left for Coutts. Mr. Lysak panicked and placed the handgun under a pillow in the trailer. And that's about it for Chris Lysak. He had forgotten that he had taken the gun with him and that he was not allowed to have it where he had it. Despite being the holder of an authorization, a permit to have the gun, he just wasn't allowed to have it at the place where he had it. That's the relevant essence of Chris Lysak's statement of fact. But now let's get into Jerry Morin's and the paragraph in particular of specific relevance. Pursuant to sections 6064, 655, and 724 of the Criminal Code, RSC 1985, Jerry Mitchell Morin admits the following for the purposes of dispensing with proof thereof on the charge that he, between February 9, 2022 and February 13, 2022, both dates inclusive, at or near Coutts, Alberta, did conspire with others to traffic firearms to unnamed persons in circumstances in which it was criminal to possess them, contrary to section 465 1C of the Criminal Code. And the only really relevant paragraphs here, paragraph 5, the emergency wire disclosed a number of conversations between Morin and people at the Coutts blockades whom he had come to know, the co-conspirators. These conversations disclosed a conspiracy to deliver firearms, ammunition, and other equipment, the quote, firearms and equipment, end quote, to the co-conspirators knowing that they sought the firearms and equipment for a criminal purpose. Then paragraph 7, on February 9, 2022, X, being one of the co-conspirators, advised Morin that there was an RCMP checkpoint at Milk River, Alberta, and numerous police present. X, using coded language, asked if Morin could bring him his, quote, guitar and amplifier, end quote. This was coded language for firearms and ammunition. Morin agreed to do so. Now, as you can see from these two paragraphs, what you basically have is Jerry Morin, one of the defendants, now agreeing to a statement of fact pursuant to which he allegedly conspired to bring firearms to the other two co-defendants, who we presume are the other two men currently detained without bail in pretrial remand, that he conspired to bring them firearms for, quote, a criminal purpose, and that is going to be the central term. What exactly does that mean under the circumstances? Does that mean conspiracy to commit murder? And that Jerry Morin, in his stipulation or agreed statement of fact, basically threw the other two co-conspirators under the bus by saying, I wasn't involved in it, I was just bringing them firearms, hence the pleading to trafficking charges, so that they could in turn use them for their alleged criminal purpose, that being conspiracy to commit murder. Did Jerry Morin basically just give what the Crown needed in order to pursue at least two of the four remaining defendants on these bogus charges? There are some other rumorings on the street, which I won't get into for the purposes of this vlog because it's not relevant and it's unconfirmed and it is rumors, which we don't need to get into. But the bottom line, you have Jerry Morin agreeing to, in his agreed statement of fact, that he was trafficking firearms to the other two co-conspirators, being the other two men of the Coutts Four, for a criminal purpose. The question is going to be, what on earth does that mean? What on earth did Jerry Morin just do here? Did he give the Crown what they needed? Did the Crown tell him, don't worry, a criminal purpose could be anything as simple as unlawful possession, and we're not going to continue to go after them for the conspiracy to commit murder? We don't know. That seems to be the best guess, that you might have had one of the defendants who pleaded basically giving the Crown what it needed to pursue at least two of the four remaining defendants, throwing them under the bus so that he could procure his own freedom. No judgment. I'm just trying to understand exactly what's going on here. The optimist in me wants to believe that the charges against the other two co-conspirators are going to fail and fall nonetheless, because how do you hold four people in pretrial detainment for over 2 years only to release two of the alleged co-conspirators to commit murder so that you could pursue these charges against the other two? Part of me wants to believe that what the Crown might do here is eke out, coerce a plea deal out of the two remaining defendants and have the criminal purpose serve as something of a scary term for the general public, so that the Crown can say, look, they pleaded guilty to conspiring for a criminal purpose, but it doesn't necessarily need to be conspiracy to commit murder against an RCMP officer. That's what I'm hoping. That's what I actually believe is going to happen still. We'll see what happens, but that is the latest development relevant in this situation. The world should know, and you can assess accordingly and let me know what you think in the comment section, because I do read the comment section and I do like picking the aggregate knowledge of the interwebs because it does actually make me smarter. So that's it. I better go get back to my what would otherwise be illegal barbecue in Quebec and see if it's ready for the meat, because we're going to have some dinner while we can still eat meat before we're forced to eat the bugs. But now you know. Everybody, if you like what I do, you know what to do. Like, share, subscribe, all that good jazz. But more importantly, now you know your vlog. Peace out, peeps.